So good morning and welcome to this week's webinar on how to draft a distribution agreement and agency agreement with Japanese partners. My name is Sofia Smerzi, and from now on I will be moderating the webinars organized by the EU-Japan Center. We are glad to welcome for this session Mrs. Lara Vittoria Luisa Tricerri. She is the founder and only administrator of two companies. She is the partner of the Italian Chamber of Commerce in Japan, consultant for the Italian Ministry of Foreign Affairs and International Cooperation, and digital TEM for the Italian Trade Agency. She has a 25-year experience in the Japanese market in the realm of export, internationalization, and digitalization. Thank you for joining us today. And to all the participants, thank you for attending this session. If you have any questions during the presentation, please write them in the chat box. They will be answered at the end of the webinar during the Q&A session. And before we start, please know that later today you will receive an email to access the slides and the recording of this presentation so that you can go back to the information, the links, and the contact details that will be shared today. And now, Mrs. Tricerri, the floor is yours.
Thank you. Good morning. Welcome everyone to this webinar course, How to Draft a Distribution Agreement and Agency Agreement with the Japanese Partners. I would like to do a short introduction before starting. So digitalization and internationalization, the COVID-19 pandemic and the current historical time have led to a change in the attitude of Japanese entrepreneurs toward the conduction of international bargaining. This article is aimed at European MSEs. I want to provide them with the appropriate tools that can put them in the position of choosing between an agency or a distribution agreement when doing business with a Japanese partner. Therefore, it is better to draft a written agency or a distribution agreement, specified terms, conditions, and contents that does not rely on the freedom of form principle. That is clear and straightforward, and that is written in English, since the Japanese languages might lead to interpretative contrast, which in event of a dispute will benefit the Japanese counterpart. So as for bigger and more structured companies, more in-depth analysis regarding anti-competitive and antitrust practices and the manufacturer's responsibility for faulty goods are needed under a legal point of view. So this is that you can see, the slide that you can see now is the table of contents that this webinar follows. These are the exact same chapters you will find in the complete report that you can download for free on the website of EU-Japan. We start with the Japan Distribution Agreement, the rule applicable to the distribution agreement in Japan. So the standard distribution agreement is a category of agreement that govern both goods and services and is signed between a principal and distribution. This category of agreement can eventually be integrated with clauses accepted by both parties. In most distribution agreements, a series of clauses preventing unfair competition are provided. These clauses can govern the term and condition of the sale for good between principal and distribution, the economic function they govern, and the right and duty of the distribution in performing sales activities. A distribution agreement can be terminated if the distribution did not pay for the product, if the distribution violated the conformity requirement of the moment of the sale, or, for example, if the parties violated their no-disclosure obligation. So the drafting up of a distribution agreement can represent the possibility of directly using the distribution network. This can constitute an advantage for distribution themselves, because if the principal trademark is strong, the distribution has all the interest in introducing it as much as possible in their network. So, and another advantage deriving from the strong principal trademark lies in the fact that the distribution, so being the part of the sale agreement, take on the inventory risk. It is better to be careful, however, as this would result in the distribution becoming the owner of the goods, and he therefore will not be subject to any fiduciary duty toward the principal. For this reason, the principal might lose track of the product, whereabouts, and the selling price. Furthermore, the price of the product sold to the end customer by the agent or distribution will differ, since distribution take the greater risk than the agent. So this is important. Therefore, the margin profit obtained by reselling goods purchasing from the principal to the client is higher than the one of the agent. So we go now to the characteristic of distribution agreement. Since the general principle for the Japanese jurisdiction regarding distribution agreement does not mention a specific form requirement, this might even be concluded orally. Specific transition or exclusive rights will have to be specified between the contract bearing in the main. To these clauses might be invalidated if conflicting with the antitrust law. On the other hand, this can also affect the distribution that through its activity limits the benefit for the principal. Furthermore, distribution shall not, during the term of such agreement, manufacture or distribute any product which directly or indirectly compete with the principal product. The principal cannot, during the term of the agreement, appoint any other distributor for the product in the territory, and cannot supply, export, or sell the product to any person another than distributor within the territory. So now we can see how restriction can be imposed on selling methods or prohibit Tricerri sales. More information of this subject can be found in the Anti-Monopoly and Fair Trade Maintenance Act 1947, also known as Anti-Monopoly Act. We are going to focus on the part analyzing unfair trade practices and the two subsegments about price discrimination and unjust low price sales. So regarding with exclusive distribution agreement, the principal cannot limit parallel import practice by different channels. So this is important. Only art, creativity, added value, intellectual property is safeguarded from copies, while the parallel import of genuine goods is allowed. A very important principle confirmed by the Japanese Supreme Court is the trademark exhaustion principle, stating that the intellectual property rights incorporated in a specific product run out when the product is launched on the commercial cycle for the country of origin. So it is valid for the trademark and for the patents. We advise to consult the antitrust law guideline concerning the distribution trade practices. That's part 3, section 2. So unreasonable inhibition of parallel import, part 3, part 2, and the impediment of parallel import. So speaking about the territory, the right of the territory depends on the clauses in the agreement. During the negotiation, it is important to remember that the distributor tend to talk with several producers and that they can also sell in the same region of product of one of your competitor, which could automatically lead to a decrease in sale, of course. Therefore, it is important to focus on the duration of agreement. We can choose freely prior to an agreement between the principal and the distribution. I suggest short term and no automatically renewable agreement. Also specify in agreement whether the principal has direct sale right, meaning if they have the right as principal to sell in the target area the same product sold by the distribution. Speaking about the setting up exclusive right, it is important to decide whether grant exclusive right for a specific product in a specific area. If exclusivity is granted, the principal must ensure that their goods are not sold to other between a specific territory. Speaking about minimum purchase quantity, product can also impose distributor a minimum purchase quantity with the aim of established profit. The setup of minimum purchase quantity can constitute an onus for the distributor, and this is why the negotiation will aim for the cancellation of reduction of minimum purchase quantity. In this case, it is possible to propose the Japanese distribution to only envisage a minimum purchase quantity and minimum purchase amount per year. Trademark and patents. Since the reseller sells the principal goods and services, it is vital to be allowed to use the principal trademark and patents. Therefore, is it better to specify in the agreement how one wants their trademark and patent to be managed? It is important to remember that when entering a distribution agreement that included a trademark license, both parties have their respective right and obligation. So not just one part. Intellectual property, IP, a non-Japanese person can own patents, units, model, trademark and drawing in Japan, but only if they live or are domiciled in Japan through the local agent. If in this country of origin as norm governing intellectual property that consider Japanese citizen as its own, so what is called the condition of reciprocity. If the country of origin has signed a treaty in the field of intellectual property with Japan, and if citizen of the Paris Convention member state, which included all European countries, are treated on equal terms with regard for Japanese citizen. Getting domain and registering trademark. With the advent of digitalization and e-commerce, it is necessary to take care of the value of the trademark through the purchase and the registration of a domain. It is advised to register a domain as a first or second level domain. No? A first level domain is .jp, while a second level domain is .co.jp. Regarding the use of trademark, distributors shall display each of trademark, logos, and marks only of BI of at the for of sole benefit of supplier, and in such manner and in such term as supplier may require or allow in the writing. Term and termination of the agreement. Usually, a longer agreement period is more advantageous for the Japanese distributor. That is why it is advisable to renew the agreement several times for a short time period of time. Why? So, because the Japanese legal system does not fix any specific rules, and this strongly limits the principal freedom to unilaterally terminate the distribution agreement with the distributor. Order and pricing. The distributor can freely fix a price and free to conduct their sales without having to respect any guideline from the principal. This is why it is convenient to include the base condition of the sale agreement in the distribution agreement, so that they are not contradiction with the distribution agreement itself. It is advisable to include this base condition in an attachment of the distribution agreement under the name term and base condition. Speaking about consideration of discount rate, the purchase price is extremely important for the distribution, and since it will have an enormous impact of their future profit and for the regular verification of estimation profit, management cost, etc. This is necessary. Distributor may place order with supplier. Any individual purchase order placed by the distributor shall not be binding upon supplier until upset by supplier. Such absence shall constitute supplier commitment to sell the product of the term set for the purchase order. About delivery, so the condition for the delivery on the product are included in the basis condition for the sales agreement, and they can be reassumed as term and base condition. It is also advisable to always use the Incoterms terminology. Why? So because this will help avoiding the contradiction in the communication between the parties. Now about the product warranty. In Japan, the concept of reliability is very important. This is why for the Japanese distribution, it is highly important to be reliable on the market by ensuring guarantee to their clients. This is why in case of complaint of the client against the distribution, even if they are the sole responsible, refer into the principal and try to solve the problem with the help of the principal. Therefore, as a distributor, it is of great importance that the principal provide the same warranty on the product and the same warranty duration the distribution provide to the customer, and that the principals safeguard the distribution from the client complaint as much as possible. The distribution will return any defective product of good to the principal, and the principal cost in the accordance with the principal instruction. Indeed, replacement of an eligibly defective product at no cost for the distribution in case of any breach of the above mentioned warranty is the principal sole obligation and the distribution sole remedy. Furthermore, any replacement of product may be performed by substitution upon mutual agreement. So we come to the last part of second chapter. Limitation of damage. Distributor take on all the risk linked to the sale, including those regarding unsold product. In particular, the distribution take on the risk for the damaging of the loss of good from the moment it is handed to the distribution by the principal. By purchasing the goods at their own risk and selling into the customers, the distribution bears the inventory risk of the good and the risk of collecting the payment of the good. So it's called customer credit risk. The distribution is only responsible for the complaint regarding the good issue by the customer. Under the principal point of view, they might want to limit to entity of their damage to avoid the unlimited responsibility abroad risk. Regarding the amount of compensation, it is necessary to individually assess that type of restriction can be enforced, and on that scale, keeping under consideration the product responsibility and the possibility of withdrawal based on the type of target product. It is in this framework that range limit and thread limits can be found. Range limit is a provision according to which the compensation of damage is directly related to cause, content, or relationship of damage. Forehead limits is a method of restriction that set an upper limit that set the liability for damage, so also referred to as capping. We now go to the chapter number 3, general terms in the distribution agreement. Here you can see sub-segment for this chapter. Confidentiality. There are many cases in which no disclosure clauses are included in the distribution agreement. If one has a separate no disclosure agreement, one should clarify the relationship with the no disclosure agreement. The distribution and supply acknowledge a duty of care and confidentiality to each other, and business information are and shall be treated as confidential both during and after the term of this agreement. Regarding no assignable, this is a disposition that forbids the transfer of the agreement status or the transfer of the right included in the agreement. Binding effect, it is a normal provision that assesses to entire of the binding power of the agreement. The entire agreement provision establishes that the content of the present agreement override the previous consultation and agreement, and that the interpretation of the agreement cannot refer to matter not described in the present agreement. It is also called parole evidence rule, and this is disposition, so in excluded verbal evidence. Regarding notices, so this provision specify that the address or the email address want a notification to be sent to be considered as a valid can be included. So the email and the email address and the address. This is very important. So regarding the force majeure, regarding the early termination of the distribution agreement, the Japanese legal system does not establish any rules, but the early termination of the agreement by the principal is admissible only in the presence of a just cause. It is important to underline that the agreement cannot be determined if circumstances that are behind the control of one of the party. Speaking about dispute resolution, in agreement, it is important to include a controversial resolution clauses, based on which it is possible to choose that the controversies are debated judicially or by arbitration. So judicially or arbitration. This is important. Governing law. So I will not explain now all the governing law, but Of course, you can find an example of governing law in the report and downloadable for free from the EU Japan website. Severability. Severability, we have the Kurabayashi Sogo, is in the event any provision of this agreement shall be held by a proper court of law to be invalid. Such invalidity shall not affect enforceability of the remaining provision of this agreement. This is a very important point. And also another caption about the headings. The headings, sub-headings, and another caption in this agreement are for convenience and refer only and shall not be used in the interpreting, constructing, or enforcing any of the provision of this agreement. So something for languages. We have another caption. This agreement is in the English languages only. Which languages shall be controlled in all respect, and all version of in any other languages shall be for accommodation only and shall not be binding upon the part. All communication and notices to be made or given pursuant to this agreement shall be in English languages. Number 4 is an example of conduct infringing the law. So again, I will not explain now, but also in this case, you will find 2 examples of conduct infringing the law in my report on the website of EU Japan. So in the report, one example, one involving a content provider, services, and one involving a company manufacturing industrial components, goods. We are going to the chapter number 5, agency agreements. An agent mediate or represent the principal in a product sales agreement between the principal and a customer in order to expand the sales of the principal product. Okay, so an agency agreement is concluded between the principal and the agent, which set for the term and condition governing the right and obligation of the agent in conducting sales activity on behalf of principal. The sales agreement for the product is concluded directly between the principal and customer. So I would like to specify that in Japan, there is no specified professional register for agent. Usually the agent has a commission calculated at the certain rate for transition in which them are involved. In this case, the agent is not a party for the sales agreement of the product, and therefore, unless otherwise agree, of course, bear no inventory risk of the product or collection risk of the product, customer credit risk. Since the distributor and agent are poorly outlined, the principle of the anti-monopoly law enforceable to agency agreement are the same as the distribution agreement. It's the same. So final chapter. In Japanese law, for agent agreement, we have the legal principle regarding the agent in Japan are in the article 27 to 31 of the Japan Commercial Code, and in the second books on commercial shops, and in the norm of article 99 to 100 28. The Japanese legislation does not require a stable, negotiable relationship of this agent with the principal. With the agency agreement, the agent undertake to sell the principal good and usually in return obtain the right to the commission. The agent is not an employee in the principal company. So this is very important to remember that. Japanese law does not distinguish between the legal person and the natural person of the agent. In Japan, agents do not need to reside in Japan. Nevertheless, to undergo the negotiation activity, it is necessary to open an office in Japan. The agent, as defined by the commercial code, is a merchant. This is necessary to register in the commercial office of judicial office of the district that has jurisdiction over the office. Furthermore, Japanese law does not envisage, with the exception of the import of specific products, plant, food, pharmaceutical product, dangerous good, etc., or for specific economic sector, financial services, construction, liberal profession, etc. Any specified norm regarding license, obligation of registration, or other formal obligation for the agent.
Thank you very much, Mrs. Tricerri, for this presentation. So let's now move on to the questions and answers. If you have any question, I invite you all to write them in the chat box. You are also free to contact the experts via email for further requests. And in the meanwhile, let me also remind you that later today, you will receive an email to access the slides and the recording of this presentation. So I already have a few questions. So the first one is, could you confirm that the imperative norms of Japanese law mentioned only apply when the parties agree to subject the contract to Japanese law?
I say to the linguistic problem, okay, caused by the Japanese, the kanji, since both the terms agent and distributor have been translated with a single word, dairiten, okay? Recently, the generic term dairiten has been replaced and from the English term distributor and agent. The sound of which, resulting from the transliteration in katakana, a syllabic alphabet used only for the foreign terms, is distributa and agento. Other two terms specific of Japanese languages are also used. The more generic dairiten that specifically refer to the distribution, and hanbaiten that refer to the agent. There is a Japanese English glossary at the end of the essay, the report, containing the most important word. So as to make them visually, you can recognize also by, so you can use, okay, and this will be a way to immediately and without error understand the type of agreement your Japanese partner or consultant is proposing or suggests to you.
Yes, I confirm that the link to access such report will be shared in the email that the attendees will receive today later. Okay, so I see there are no new questions, so I will now close the session. Once again, thank you, Mrs. Tricerri.